Hey folks, welcome back to the channel. In today's case, a mother faces the court from jail after a series of troubling events, including being under the influence during a high-speed chase with her child in the vehicle. That event resulted in her child being placed in the care of grandparents. Let's watch as the court examines how these events unfolded and what they mean for the child's future.
Bench trial as it relates to the parents of these children. May I have the names of our participants, please? And then we'll get to, one child, and then we'll get to the bits of a sidebar that are going to direct, I think, this afternoon's proceedings.
Can I ask if we're going to be on YouTube?
We are.
Thank you.
Okay. Appearances, please.
Katerina Dumont, lawyer for any item.
Ms. Saja Thomas, counsel for the department. Your Honor, Ms. Jamie Freeze is the CPS worker. She's very sick today. I told her that her presence would likely not be necessary. So she is on standby if the court needs her, but I just wanted to inform the court of that absence. And also present is Ms. Brandy De La Garza, and she is the current foster care worker.
Thank you.
Michael McFarland. Oh, sorry, I'll let them introduce themselves.
Brandy De La Garza from Fostering Solutions, the foster care worker.
Michael McFarland, representing mother. Please introduce yourself.
Victoria Dehart.
You need to get a little closer to the microphone. You were breaking up.
Victoria Dehart.
Much better. Thank you.
What's the last name? Nito?
Dehart, I believe. Dehart. Is that right, Miss Victoria?
Yes, Your Honor.
Okay, got it. Thank you. All right. Mr. McFarland, would you like to make some comments about the sidebar?
Yes, Your Honor. Obviously, my client is in jail, unable right now to parent for her child. She is in jail based upon the same concerns that are in the petition, which are number 8, 9, and 10. Therefore, we would be requesting to enter into a no contest plea. I've discussed with my client. She does not need the petition reread. At this point in time, she's done some classes in jail, like a family team meeting to discuss what the case service plan would look like. We realize that there'd be a psychological evaluation, a drug evaluation, parenting classes, also help with housing, I should say, transportation. These are some of the numerous concerns that we think would be addressed in the case service plan.
All right. Any objections, Ms. Thomas?
No, Your Honor.
Now, I should also add that we talked about waiving the workers testifying and relying upon the petition itself, which I have no objection to.
Good. I understand that did come from you originally, Ms. Thomas. Is that right?
Yes, Your Honor, that was in hopes that Ms. Freeze would not have to log in and testify.
All right, Ms. Dumont, you find the plan for the no contest plea to serve the best interest of the minor child in this case?
Yes, Your Honor.
Any thoughts on using the contents of the petition in lieu of the testimony of the worker?
I would stipulate to that for the factual basis as well.
Very well. All right, Deputy Ames, would you swear in Ms. Victoria Dehart, please?
Is she on the screen, Your Honor?
Yes, she's coming to us from jail.
Thank you. Please raise your right hand. Do you swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes, I do.
All right, Ms. Dehart, have you been able to look over a copy of the petition dated September 20th, 2024?
Yes, I have, ma'am.
Very good. You had a chance to talk to Mr. McFarland about that?
Yes.
All right.
Before this in the breakout room.
Okay, good. So he's put on the record that you'd like to enter a no contest plea, meaning that you wouldn't admit necessarily immediately to me what's been happening in the petition, but rather that I would consider what's in the petition to be accurate completely. In other words, If I accept your no contest plea, I'm accepting effectively what's in the petition in its entirety. Do you understand that?
Yes, ma'am.
Very well. And there would be a case services plan built around that, which Mr. McFarland has already talked about some of the things that would be asked of you to accomplish. Did you hear all that?
Yes, Your Honor.
All right. All right. If I accept your plea, you're giving up your right to a trial by judge or a trial by jury. The right to have the petitioner prove the allegations in the petition by a preponderance of the evidence. The right to have witnesses appear against you and testify under oath at trial. The right to cross-examine those witnesses. And the right to have the court subpoena any witnesses that you believe could give testimony in your favor. Do you understand you'll be giving up or waiving the rights I've just indicated to you if you enter a no contest plea?
Yes, Your Honor.
With regard to the consequences of your plea, or in other words, what will happen, the court will do the following. There will be continued investigation by the caseworker to see what the problems are in your family and how and whether they can be solved. The court could dismiss the case if there's no need for the court to be involved. If it appears that there's a problem that may be solved, the court can make the children temporary wards of the court, place them with mother or father or with relatives or in a foster home, and order programs for you and your child, such as counseling, drug and alcohol treatment assessments, and parenting classes. If it appears that you will not be able to provide a proper home for the child in the reasonably foreseeable future, the court could terminate your parental rights. In regard to the plea itself, the plea can also later be used as evidence in a proceeding to terminate your parental rights. Do you understand the consequences of your plea, Ms. DeHart?
Yes, Your Honor.
Do you have any questions about any of the information I've given you so far?
No, Your Honor.
Is anyone making you enter a no contest plea?
No, Your Honor.
Has anyone threatened you in order to get you to enter a no contest plea?
No, Your Honor.
Has anyone promised you anything in order to get you to enter a no contest plea?
No, Your Honor.
Are you under the influence of drugs, alcohol, or anything else that could get in the way of you understanding what you're doing this afternoon?
No, Your Honor.
Very good. Would you say your decision to enter a no contest plea is one you've made of your own free will?
Yes. Yes, Your Honor.
All right. All right. As I look at the petition, for purposes of the factual basis of the plea, obviously you are coming to us from Lenawee County Jail at this time. Is that right?
Yes, Your Honor. It is.
Thank you. All right. It would appear that there are some criminal charges, and as a result of that, for example, a high-speed car chase wherein the child was in the vehicle. It was thought that Miss Victoria DeHart was under the influence of substances at that time, and she did leave the child in the car. The grandparents came to pick up the child. Ms. DeHart did try to retrieve the child a day or two later, got into a physical altercation with some family members, it looks like, and then fled the scene before law enforcement arrived. That was at the original altercation. Since that point in time, until the filing of the petition, it would appear that the child was left with the grandparents without legal authority to continue to take care of the child. And against the will of Ms. Victoria DeHart, who did appear at one point asking for the child, but was denied by the grandparents at that time before disappearing again and coming to us here today from jail. Additional facts and circumstances for purposes of the plea, Ms. Thomas?
Thank you, Your Honor. I would also just, if the court would be willing to accept, I guess, recognizing the other portions of this record since we've been here on the preliminary hearing back in September. This is the first time that Ms. DeHart has been able to join us. And so for several months, she was not available to the child for care and custody. I think that in addition to the substance abuse concerns, the psychological, as Mr. McFarland noted, also some parenting education would be needed, and especially rebuilding that bond once she's available for some parenting time. And I think that There was a court report provided back in November, which would outline a sample of a case service plan, and I think that it is accurate in addressing or sufficient in addressing the issues that face Mr. Hart at this time.
Does look like there's documents that were received by the court November 13th, 2024 and November 19th, 2024. Another set of documents filed January 6th, 2025. Are you asking about all of that or a section of those?
Your Honor, for the factual basis, just the petition. I noted that simply for the record, so we can develop the case service plan and or admit it in the future based on those facts that we also have.
As to the factual basis, Mr. McFarland.
Well, I think what you stated in the petition is what we need, Your Honor. As far as the case service plan, I'm not objecting to that, but I do think family team meeting or at least my client discussing that with the ongoing worker would be the way to proceed. I'm not sure that she has viewed that potential case service plan or had opportunity to discuss it. There may be some more things that she might need that are not in there.
Anything for me, Mr. Mott?
No, Your Honor, I'm satisfied.
Thank you. All right, so we'll, just to confirm, I have looked at the petition for purposes of the factual basis. Obviously, there have been some preliminary hearings and some other things that have been happening. But in short, I think the only additional thing that would be super relevant at this juncture for adjudication purposes would be the extended disappearance of your client. Mr. McFarland?
Yes, Your Honor. Taking a look back in November 27th, we had mentioned that there was ICWA inquiries as to paternal grandfather indicated native heritage. Do we have any documentation on that?
Okay.
And I'd like to at least ask my client the ICWA question again.
All right. Are you satisfied with the advice of rights and the factual basis of the plea?
That I am.
Ms. Thomas?
I am, Your Honor.
Mr.
Yes,
Bush?
Your
Very good. Court is also satisfied that the plea is knowingly, understandably, and voluntarily made with a full understanding of the consequences. And I would agree. I think as it relates to this case, we were looking for some Native American heritage searches, whether they were historical or current. Ms. Thomas, could you speak to that?
Your Honor, my file indicates that ICWA documentation was sent out on or about September 20th. The court should have received a memo on or about September 25th with that information. Would have been presented for our pretrial hearing or preliminary hearing that was set on September 27th, 2024.
A memo?
Yes, Your Honor, there should have been all of the, it's about 21 pages in length. And so the inquiry with the certified receipts and the petition as to what was sent, is included.
I've pulled up my notes. Okay, so it looks like on the legal parentage issue, we were looking for a copy of the order or the AOP and also a death certificate potentially for Mr. Tyler Hubble. The ICWA inquiry status was noted to be that the inquiry was sent and we received certified mail proof that it was sent to, looks like 6 tribes plus the BIA. So we would look for the green card receipts or any any denial letters from those tribes as of today.
And Your Honor, I don't have an update on those.
All right.
Your Honor, I do have a copy of the AOP.
Okay.
I received that at the beginning of October. So I can email that to everyone if they do not already have it.
Very well. Well, and as I referenced earlier, I have a number of documents that are just floating in this file. So hopefully we'll be able to look at those at the initial disposition, or we can look at them today, whatever you want to, however you want to handle that. But absolutely, I would need a copy of that AOP, and then preferably a copy of the death certificate as well on the father. Including, of course, the update on the Native American heritage searches.
Yes. Your Honor, I would ask just to be able to submit any of those things at the initial disposition, just to ensure working between the department and the foster care agency that we have all of those things for you.
That's fine with me. Okay, so did that answer your question then, Mr. McFarland, on the ICWA?
It did, Your Honor. Thank you.
Very good. All right, so for purposes of the adjudication order, I will indicate that there are several sections of MCL 712A.2B that apply in this particular case, specifically that home or environment by reason of criminality. And that includes, of course, the use of illegal substances as well, impacting the parenting of Mr. Hart, as well as failure to provide care and custody for the child or other care, in fact, as well, indicated as necessary for him. And now let's look for the initial disposition date.
It did occur to me, the one question I had is from my client, and if I could ask her that one.
Okay.
Ma'am, do you have any Indian blood in your family line that you are aware of?
Yes, I do.
Okay. And what tribe do you believe that might be?
I know we had Cherokee, we had Blackfoot. I think that's what I know of so far.
Are there any relatives alive who could provide any additional information on that?
No, but my mom's dad, my grandpa Joe, right before he passed away from lung cancer, he had done a search, and he knew that he had enough, and that my mom would have enough, and I should. So.
Okay, I can't understand what you're saying. Could you slow down, please, and get a little closer to the microphone?
Pick up with your grandfather.
Yeah, my dad and my grandfather. So my mom's side and my dad's side both have it.
Thank you.
All right, thank you.
And would your mother or father be the contact people to ask that question?
If they had the paperwork.
If they can provide the worker with any knowledge that they have.
I'm not quite sure, but they might be able to if yes.
Okay, thank you. That's what I need to ask you.
Thank you. It would appear that the inquiry was conducted in cooperation with the grandparents, but we'll ask for the confirmation of that at the next hearing, because I know Mr. Hart was not available to us at that initial inquiry stage, and nevertheless, there were 6 tribes plus the BIA that were requested to do that search, including a couple of different Cheyenne and Cherokee tribes. But we can continue to look at that moving forward. All right, anything else before we find our disposition date?
No, thank you.
Very well.
Pictures, not the pictures.
Looks like Friday, February 7th at 2:30 is available.
That's fine by me.
That works, Your Honor.
Right, very well, thank you. Mr. McFarland, would you like us to make some time for you to talk with your client about the proposed case services plan that was provided before we let her go for today, or would you prefer that she just try to get a hold of you if and when she...
How about now? I think that'd be the best way for me to do that.
Okay, very good. All right, so Mr. Hart, what's going to happen now is Mr. McFarland's going to talk with you about the proposed case services plan, which will be what the court will be discussing on Friday, February 7th at 2:30 for purposes of your initial disposition. The case services plan would track progress that's been made by you on some of the issues that were identified today, as you try to improve your situation both for yourself and your child. Do you have any other questions?
No, Your Honor.
Very good. Between now and when we come back on the 7th at 2:30, the child will remain placed with relatives from both sides and continuing to enjoy that bond and support as Ms. Victoria DeHart begins her journey in deciding what services she might want to undertake so that she might be available to her son in the future. But for now, he is placed in the safest and least restrictive circumstances. Would you wish to make any other reports or comments today, Ms. Dumont?
Your Honor, I did file a physical report, but I did meet with a minor child on Friday at his school. He's in Head Start, he's doing well. I spoke with both the DeHarts and the Hubbles with regards to their stipulation on parenting time. They're close to 50-50 at this point, and both sides are doing well. There's little hiccups, but that's to be expected. The minor child is adjusting well to overnights that he didn't have previously with the Hubbles. Head Start's going well. They said there's no developmental delays that they can see. My one question was, I thought at the last hearing, family counseling was ordered. I tried to find that somewhere. I didn't see that, but I just wondered if that was something that the court would want the family to participate in. I know there is one in Brooklyn that is close to both sides residents and willing to help.
Yes, that is accurate. I had indicated that that should be part of what happens. The order dated 12/5/2024 in fact says JH should be referred for individual and family therapy, which should include both sets of grandparents.
Okay.
So you're absolutely right, and that should be something we'll be looking at the next report.
Yes, Your Honor. I don't believe it's started as of now, but hopefully they can get that implemented.
Great, thank you for asking.
Your Honor, how do we wish to address parenting time in the event my client is released prior to our next court hearing?
Well, we would leave that to be arranged by the caseworker, which means that she'll have to be reaching out to Ms. DeHart to monitor obviously her progress on her criminal case, as well as to find a way that best serves her opportunity for supervised parenting time between now and when we come back. In other words, family team meeting is the best way to approach that, or to allow the caseworker to tackle that, considering that your client's coming to us currently from Monterey County Jail, and then there may be changes between now and when we come back.
That's what I anticipate, Your Honor.
Any other issues for today?
I'm just checking to see if attached to the court report is a case service plan.
Yes, it was attached to one of the packets. I have a proposed one up here if you need it.
It's not for today, Mr. McFarland, it was for the November hearing.
I'll borrow the court's pack, maybe.
Okay.
Oh, I do. I have the proposed case service parent plan agency agreement. I have it.
All right, anything else for today?
I may stay here if it's easier for me to read this and then.
That case shed light on the impact of destructive decisions. The defendant has a difficult road ahead as she faces the challenges tied to substance abuse. The court placed the child with grandparents, which was really the only option. That's great, but I can't help but wonder, how is the child processing all of this? And what happens to a mother-child bond after choices like these are made? Let me know your thoughts in the comments. And don't forget to like, subscribe, and hit that notification bell for more gripping courtroom moments. Thank you for watching. See you in the next one.